There's all this preparation that goes into trials, but a pointing finger can make all the difference. A lot of prosecutors are trained. They are trained to do one thing and one thing well: point at the defendant. And they're going to get relatively as close as possible. Once they're given their opening statement, they're going to come up and say, these are the facts, and we intend to prove beyond a reasonable doubt that this person, the defendant, and they're going to get as close as possible, but it's going to be pretty close. It's going to be uncomfortably close, and you must prepare your client for that point. 9 times out of 10, every prosecutor is going to do it. They're going to try to get as close as possible, to try to antagonize the defendant and hope to get a response or a rise out of them. The jury is always watching the defendant, and the prosecutors know that. And the prosecutors also know that in the majority of the cases, the defendant will elect not to testify because they have no reason to testify. Why? Because the prosecution, the state, the government, they always have the burden of proof. They have to prove beyond a reasonable doubt that the defendant committed these crimes and every element of those crimes. And the clients have to understand that it's a possibility, a probability that it will happen. And when it does happen, they can't respond that way. They just can't respond that way.